Hello, everybody. I hope you all are doing good. Yes, let me see. So मुझे ये चेक करना है कि मेरे फोटो की वजह से आपको पीपीटीज में कोई दिक्कत ना हो. That's why I'm doing setting. So this whole setup is new for me. That's why I'm taking some time. All right. One second. Give me 1 second. All right. So the system is actually initiating it. It took some time. So in this particular PPT, we will going to see how does the case is actually committed to the court of section. All right. All right. I hope this screen is visible to you. Okay. So now first we need to understand how does the cognizance of an offense taken place. All right. तो देखो सबसे पहले क्या होता है जैसे ही कोई ऑफेंस होता है सो वैसे ही एफआईआर दर्ज की जाती है. ओके, एज सून एज द कमीशन ऑफ द ऑफेंस टुक प्लेस एफआईआर हैज बीन रजिस्टर्ड. ऑलराइट. सो आफ्टर द एफआईआर it is the duty of the police officer to investigate the case. Now, after investigation, it he is duty bound to submit the police report. So, police report has to be submitted before the court of magistrate. All right. Now, it is also essential that it may be possible after the investigation, after the inducing of so many evidences, it might be possible that no offense has been committed according to the police if he has gone through all such kind of investigation. So it may be possible that apart from this police report, they may submit a closer report as well. But now we are going through that situation in which after the investigation of the offense, we came to know that some kind of offense has been committed. So now the police officer do what? It will submit the police report. All right. And this police report is also called as a charge sheet. Now, these charges has to be submitted before the court of magistrate. Now, the court of magistrate do what? It will take the cognizance. Okay. Now, it is now on this police report, the judicial magistrate is duty bound to take the cognizance of the offense. When you read about this cognizance, you have to understand what do you actually mean by this cognizance. So the cognizance is the situation in which the judicial magistrate came to know about the offense. Okay, so when the judicial magistrate has get to know, has a notice about the offense, now this stage is called as a cognizance. Now in most of the cases, if you read about section 200, I think 210 of the BNSS, which specifically talks about what which talks about how the who is competent to take the cognizance, and on which particular cases the cognizance has been given. For example, in 210 of the BNSS, which talks about cognizance can be taken on police report, and it can also be taken on a complaint cases, and suo moto also cognizance has to be taken. Earlier, this provision of cognizance related is given under, I think, section 190 of the CRPC. But in BNSS, the provision related to the cognizance has been given under section 210 of the BNSS. All right. Now, you have to understand one thing is that JMFC, okay, in 99% of the cases, JMFC is authorized to take the cognizance. But there are situations in which judicial magistrate second class is also authorized to take the cognizance of the offense. Now you have to understand when does this JMFC are competent enough to take the cognizance. So judicial magistrate second class will take the cognizance of the offense only in those cases in which they are particularly empowered by the CGM. When the Chief Judicial Magistrate empowered the Judicial Magistrate second class, only in these particular cases, Judicial Magistrate second class is competent to take the cognizance. After taking the cognizance of the offense, now what happened? It is the duty of the magistrate to conduct an inquiry. Now, during the inquiry, what they can see actually by looking at the schedule, they came to know that this is the particular kind of the offense which has to be tried by this kind of magistrate only. So now, what happened if there is specification that this is a case of the murder? So for the murder, the trial has to be conducted by only court of session. All right. So in this kind of situation, committal proceeding took place. So originally, if you even read out this section, I think 213 of BNSS, which specifically talk about cognizance in case of court of session. So they have directly mentioned that cognizance can never be taken by court of session directly. It has to be submitted through the committal proceedings. Okay, so you must have some understanding about the committal proceeding. So if we specifically talks about the committal proceedings, then they have been given under 232 and section number 362 of the BNSS. All right, ये सभी चीजें we will go in very depth in our next proceeding sections. All right. So now, what you need to understand is that by looking at the schedule, now the judicial magistrate came to know that this is the kind of offense which I am competent enough to take the cognizance, and also I am competent enough to try this particular case. All right. Now the magistrate has judicial magistrate has first class has three powers. It can basically, by looking at the schedule which are given under the BNSS, he came to know that I'm competent enough to try this particular case, or he can do what? He can even transfer the case to the other judicial magistrate first class. All right. Now, next moving ahead. Now, if you read the section number 21 of the BNSS, which talks about which are the courts according to the BNSS or to in any other law, which is competent to try the particular offenses. Okay, I'm having slides of section 21 as well. I will talk about that section in afterwards. Okay, now for this particular understanding of the section, you must have very basic knowledge about it. Is that the High Court and the Court of Section, they both are having concurrent jurisdiction of the offense. So when you read about section 21, they have clearly mentioned that if you want to see the competency of the magistrate to try the offense, then you need to see the schedule. Okay, so whatever be the magistrate which are authorized under the schedule is a different thing. But apart from the magistrate which are mentioned under this kind of schedule, High Court and the Court of Session, they are also having a concurrent jurisdiction to try those offences. Now we need to check we need to check how the cases are being able to be tried by this High Court and even Court of Session in their original jurisdiction. See, look, I will tell you one simple example. If any kind of offense is such a kind that it has a very hard impact on the national interest, okay, if it is public interest involved, then in that kind of cases, High Court will directly withdraw. Okay, whatever be the case is tried by the judicial magistrate, then High Court do what? It can withdraw it by himself and try these kind of particular cases by itself. Okay, now Court of Session, we also deal it in our next slides. Okay, now, with respect to the offense of BNSS, now I have already told you the High Court and the Court of Session also have a concurrent jurisdiction. Okay, अब यहाँ पे क्या लिखा है? Along with the court mentioned in the first schedule. Okay, so the courts which are specifically mentioned in the first schedule, they are having the jurisdiction, but apart from that, both High Court and the Court of Session has a concurrent jurisdiction to try the particular offences. So now the general rule is that you have to understand this general rule, because if you understand this rule, you will get to know about most of the committal proceeding. The general rule is that the judicial magistrate, I have already told you that in 99% of the cases, judicial magistrate first class is competent to take the cognizance. So now the magistrate who is taking the cognizance of the offense, he is also empowered to take to conduct the trial for that particular offense. So now you must think that if the person who is competent enough to take the cognizance of the offense, he is also competent to conduct the trial. So now in this particular situation, you can say that originally it is very rarest of the rare case that the committal proceeding happens. Okay, but there are situations in which the case has to be committed. The case has to be committed before the Court of Session under Section 262 and Section 362, sorry, 232 and Section 362 of the BNSS. Okay. Now, let's try to understand the offense of murder. Okay. Now, I have told you I have to be proceed. Now, I have already told you that in most of the cases, 1 second. Like I have already told you, the offense of murder. Okay. For example, the offense of murder. I think my laptop is having some problem. I can't handle it so, so much. Now my laptop is started to heating up. I don't know why, but still, I would like to continue. Okay, now if I'm talking about it, that originally what happened, generally what happened, that the person who is competent enough to take the cognizance is also having a power to try that particular cases. Okay, but now we are in what condition the transfer would take place. Now let's try to understand this scenario. FIR happen. After that, FIR investigation would take place by the police officer. Then, in order of that investigation, police report has been submitted in the court of magistrate. On that particular police report, now it is the duty of the magistrate under section 210 of the BNSS to take the cognizance of the offence. Now the magistrate has conducted an inquiry. Now, what happened by looking at the schedule? Okay, now from the very first instant, what happened during the inquiry itself, the magistrate looked at the schedule, and by looking at the schedule, he will get to know that this is the kind of the offense which has to be tried particularly by the this is the kind of offense which has to be tried by the court of session. Now, this is the situation in which committal proceeding comes into play. Now, the judicial magistrate first class is not competent enough to try the cases which are related to the murder. Okay. Now under section 232 and under section 360 232 and under section 362 of the BNSS, now the committal proceeding took place. Okay. Now, when the magistrate takes the cognizance, okay, for the offence, now even you have to understand that judicial magistrate first class has a broad area in respect of cognizance. They are competent enough to take the cognizance even in the case of murder. Okay. Now, after taking the cognizance, now it is the duty of the judicial magistrate first class to transfer this particular case in the court of sessions, because court of session is the only competent authority to try the cases of murder. All right. So now you have to, by looking at this slide, you have understand that why these committal proceedings are very relevant. Now, we have to understand now the submission proceeding. Okay, we have to understand what are the kinds of submission proceeding. Now, for the submission proceeding, you have to understand one thing. The submission proceeding took place only in the situation in which the judicial magistrate has to transfer the case before the chief judicial magistrate. Okay, when the when the judicial magistrate has to transfer the case before the CGM, then these kind of proceedings are called as the submission proceedings. Now you have to understand one thing: committal proceedings only happen in that situation in which the judicial magistrate has to transfer the case before the court of session. जहाँ पे नीचे वाली कोर्ट जो ऊपर वाली कोर्ट को जो भेज रही है वो कोर्ट ऑफ सेशन होगा, तभी वहां पे कमिटल प्रोसीडिंग बोला जाता है. एंड व्हेन द particular judicial magistrate transfer the cases before the chief judicial magistrate, then such kind of proceedings are called as a submission proceedings. All right. Now, there is an offense. Okay. Now, the submission proceeding, why do we need such kind of submission proceedings? Now, for that, you need to understand one thing is that even though if you have seen the schedule thoroughly, then you will get to know that even these judicial magistrate first class are competent to try those cases in which the punishment may be up to 7 years. Okay, so now since they are competent to try those cases, it doesn't mean that they can give a punishment up to 7 years. Okay, since they are competent to try such cases, it doesn't mean that they are competent even to give punishment up to 7 years. So there might be a situation happen that if the gravity of the offense is such kind that he wants to give him the sentence which is beyond its competency. Okay, for example, if we talk about judicial magistrate first class, if you see section number 23 of BNSS, then you will came to know that judicial magistrate first class is only competent enough to award a sentence which is up to 3 years only. Now, after looking at the gravity of the offense, now the judicial magistrate first class is thinking that this is the offense in which I think that he has to impart more punishment beyond my competency. Now, here the submission proceedings comes into play. Okay, now, for the submission, if you look under section 364 of BNSS, now there are three basically ground in which the submission proceedings took place. Okay, for your better understanding, I am telling you, if you see the section 364 of the BNSS, and if I'm not wrong, it was section 324, 325 of the CRPC, which talks about the submission proceedings. All right, now if you see this particular section, then if the judicial magistrate wants to give a punishment which is different in kind, okay, wants to give a punishment which is different in kind, for example, judicial magistrate first class is not competent to give a punishment which is related to the confiscation of the property. So since he is not competent enough, so what he can do, submit the proceeding before the he can submit the proceeding before the chief judicial magistrate. Second thing is, when this submission proceeding comes into play, when he is not competent to inflict a punishment greater than 3 years, then obviously he required a submission proceeding. Third situation arises when the judicial magistrate second class wants to fill a bond. Then in these cases submission proceedings also took place. Now, I have already told you, if you read this section 21 of BNSS, now if the offences has been committed, now this section 21 talks about what, which are the courts which are competent enough to take, to conduct the trial. Okay, so whatever the offences which are happened under BNSS, so under this High Court, I have already told you in the earlier slides that High Court and Court of Session, they are also having a concurrent jurisdiction to try the cases in its original jurisdiction. Okay, and after that you schedule. Okay, if you see the schedule, they are also mentioned that this is the kind of magistrate, and this kind of magistrate will try this kind of offenses. Okay, if it talks about other offenses, means this kind of offenses in which the law has created that this kind of particular offense has to be dealt by this court. Okay, for example, in postcode they have strictly mentioned that offenses related to child has to be strictly dealt by court of session. If there is a special court, then only that special court is competent enough to try this kind of particular cases. Okay, next thing is High Court. Okay, High Court is also competent one. And after that, if there is no special court and High Court is also not trying this particular offenses, then you have to see for the other offenses schedule and specifically classification number 2. Okay, specifically classification number 2. Now, in आने वाली slides में we will understand in deal will all this section 232 and 362 in a very in depth way. Okay, so now 232 I have already told you that the offences which are exclusively tried by court of session. Okay, then there will be a committal of the case took place under section 232, and in which 362, when the judicial magistrate initially, if you read this 362, you will came to know that initially by looking at the schedule, judicial magistrate think that this is the kind of offences that I am competent to trial. But later on, during the trial, uh, by more and more evidences, now the judicial magistrate think that this is the kind of the offense which I am not competent enough. So now this offense has to ought to be tried by court of session. So now in this particular cases also, what happened? committal proceeding would take place. Now, next we will understand the grounds for committal proceeding. Okay, what are the grounds for the committal proceeding? Since the very first thing is when the judicial magistrate, okay, when the judicial magistrate, by looking at the schedule, he was thinking that initially it was found by the judicial magistrate first class that this is the kind of offense which I am competent enough to try the case. But later on, he realizes that I'm not competent enough because this is, for example, theft happened. For theft, judicial magistrate is competent. But on later stage, by some kind of evidences, judicial magistrate found that along with the theft, murder has also been committed. Now, for the murder, he is not competent to trial the content. So in these kind of particular cases, what happened along with the theft? Now, this murder, theft plus murder, this kind of proceeding is called committal proceeding, and this committal proceeding has to be submitted before the court of session. All right. Now, if the gravity of the offense is such kind that and the public interest is also involved, then also committal proceeding would take place. All right. Now there is a question in front of you. Now, if the particular case has been tried by the judicial magistrate, first class, now can the accused person and the aggrieved, the victim, can by mutual agreement will commit the proceeding before the court of session? No, it cannot be happened. Now it is another thing that they will actually make an application for the committal, but the ultimate जो discretion होगा कि it has to be committed before the court of session or not, it always lies with the court of it always lies with the magistrate only. That's all for now. I hope this would be helpful to you.